I'm just pausing as usual to see that the audience populates. Okay. Yeah. Still popping up. All right. I think we could get started.
Calling the meeting of the California Law Revision Commission to order. Do we need to call roll?
We can.
Do we have a quorum?
Commissioner Carrillo,
Present.
Carrion,
Present.
Cubas,
Present.
Hebner,
Present.
Jenkins,
Here.
Calra, not present, King,
Here.
McAllister,
Here.
Roth, not present, Simpson.
Here.
I believe we have a quorum.
Yep.
First item of business.
Is the minutes memorandum 2318.
Is there a
Staff
motion?
has no proposed changes.
Is there a motion?
So move.
Can we call the
Second.
roll? Been moved and seconded. Can we call the roll?
Yes. Commissioner Carrillo,
Aye.
Carrion,
Aye.
Cubas,
Aye.
Hebner,
Aye.
Jenkins,
Aye.
King,
Abstain because I wasn't here.
okay, McAllister,
Aye.
and Simpson.
Aye.
That measure passes.
Next in order.
Would be the executive director's report. I guess the big news is that we canceled the closed session. We had intended to use it to start the process of screening applicants for the upcoming executive director vacancy. Despite having done very broad advertising and outreach, we had not enough applicants to really feel like it was due diligence to proceed with the pool that we had. No reflection on anyone who did apply, but just the process-wise, it seemed like there wasn't enough to be sure that we were getting a good selection to sample from. So I have renewed certain of the advertisements for an additional period, and I'm also doing more targeted outreach to specialty bars. So the hope is that we will instead have the closed session in May, and at that point we'll be ready to take a look at the applicants and start making some decisions about who we want to advance to an interview. So sorry about that. It surprised me. Because of that closed session, the agenda is going to be pretty light. I spoke with Tom Green of the antitrust study, and he agreed to start his presentation at 10:30 rather than 11. So as soon as we've cleared the administrative matters out, I think we should turn to the ERA study, because we have our law student extern, Grace Wiley, is here, who's going to be presenting the memo that she principally drafted. There are a couple of interesting bills out in the wild. One is a bill from Senator Laird, SB 544, which would permanently remove the obstacles to having easier teleconference meetings. So that's sort of the shoe I've been waiting for to drop. It's not, from my perspective, it doesn't go all the way to curing the problems that we're expecting to have once we go back under the existing obstacles to teleconferencing, in that it would still require that there be a single physical location open to the public. So while everyone else could participate by teleconference, we're going to have one physical anchor, which means we're going to have to, if we go that route, we're going to have to run a hybrid, as we did with marginal success last year, where the physical location is set up with video, audio, internet connection, so that the physical location can be one of the participants in the teleconference and everybody else dials in remotely. One good thing they did do is that they made clear that a staff member can be present at the physical location. It doesn't have to be a member of the commission. So that's operationally simpler. And I think that was a good idea if you're going to require the physical location. So we'll see. The other thing is it's not an urgency bill. So the soonest at present, the soonest that it could provide any kind of relief to us would be January 1. The other bill that I just got.
Brian,
Yes.
Brian, I'm sorry, before you move off that, a question on that. Would there be any prohibition to using pro bono law firm space for the in-person part of the hybrid?
No.
Thank you.
As long as it's open to the public and we in advance in our agenda notice the location and make clear that people can go there. Commissioner Creel?
Yeah, I had a similar related question. It occurred to me that the Berkeley Law School has a really big auditorium. It's set up for full AV, it's a conference venue. So we use it for that kind of thing all the time. And I was anticipating that we might have to go back to in-person meetings after the end of the fiscal year. So I don't know if there'd be, for some reasons, it would be easier to post up at, at your location at UC Davis. But if there's any interest in coming to Berkeley, then I could certainly get Berkeley Law's conference space for us.
Well, I will follow up with you about that. Not so much because I think that I want to, well, who knows? It might make sense. We certainly have hopped around more in prior years than we have recently, going to other cities. There is an operational advantage to meeting in Sacramento because it makes it easier for our legislative commissioners and legislative council to attend the meetings.
Yeah, it occurred to me that we might wind up using multiple venues, so I thought I should offer one. Sort of, rotating the pain or of the most mutually inconvenient location for everyone.
Well, the thing I was going to say that I cut myself off is going forward, starting next year, if hybrid meetings are permissible, a location that's already well teched up and has staff available to run the tech would be a big advantage. It would save us having to cobble together our own technical solution and dedicate somebody to run it.
I can provide that. My term expires later this year, but even if I'm not appointed, I'm still going to be at Berkeley, and I'll still be a friend of the commission. So if there's interest in sometimes or even permanently, semi-permanently, using a physical location like that for for the public post up, I'm happy to try to make that work at Berkeley Law if that's convenient.
And I see a couple more hands. Commissioner Jenkins, I think yours went up first.
Actually, it was Commissioner Carry-On was waiting.
Thank you, no problem. Just one thing I wanted to note, that if we are looking at using space from law firms, that we should be thoughtful about whether those law firms represent any entities that might be interested or have some kind of interest in the antitrust work. Obviously, we want to ensure that there's not even a perception of bias. So I think that might be something to keep in mind.
Good point.
Good point.
So I just wanted to add that we recently revamped one of our floors in one of our buildings, and we have a Zoom room now that might be a good venue for this, because it's already, it has all the tech set up, and we could make it available to the public on a just for these meetings, and it might work out well for this purpose.
That's a great suggestion too. Thank you.
Those will be some options.
And Brian, my comment about law firms and existing space is less to share the pain around and more to recognize that for many of us traveling for a total of 6 to 7 hours in order to spend 4 hours productively at a meeting makes virtually no sense.
Yeah.
I'm assuming we're not going to go back to what we did in the old days, which are 2-day full hearings with an overnight. And if that's the case, eliminating travel for as many commissioners as possible allows us to put in full work days rather than spending slivers of work days working and the rest of it just causing the state expense for
Yeah.
moving us around.
I agree. And that's why, I mean, that's part of the reason why I tried to develop a hybrid solution last year. The other reason is because it's, I think, really beneficial to be able to loop in remote participants, like having Tom Green donate his time to make these presentations has been enormously valuable. And I will note that this is his last presentation, so I want to be sure to thank him when he's done. I don't know that he would have been as available to do this if he had had to travel to Sacramento every time to make the presentation. So I see a lot of advantages to trying to preserve some kind of a teleconference element. But that's, at least right now, January of next year before that would be permissible. So we're going, in the second half of this year, we're going to have to cobble something together that's, I assume, going to have a physical location, unless the governor steps in and does an executive order. The politics around this seem tangled to me. Like there's so much that's obviously beneficial about holding these meetings by teleconference, including in terms of public accessibility. I think these meetings are more accessible to anyone, but especially to people with disabilities, than if we were cloistered in some hearing room in the Capitol. But on the other hand, I think the counter argument is coming from transparency advocates who are very worried about erosion of anybody's ability to show up and face, petition their government in person. So I get it, but I'm hoping that there'll be a compromise. Commissioner Carrion, did you raise your hand again?
Yes, I just wanted to make a comment. I think that I agree with what you're saying, Executive Director, because I myself, for example, would not have been able to attend today's meeting if I had to go in person because my child is sick, right? And there are people who are caretakers, and we've seen, in the midst of this pandemic, what that's done to our society. I think that it really does hurt the ability for people who are interested and vested. Obviously, I'm vested as a commissioner, but I can just imagine as a member of the public who is not someone that comes here regularly, but is very interested in the subject matter, that would not have access to that. And that is incredibly unfortunate. So I really do hope, and I thank you for your work in looking at, different hybrid options. Because this is just work being practical on how are we going to get, the public to be able to participate in these meetings that are so very important in the way that we're going to be shaping the law and introducing new law that affects them.
Let me ask a related question. I had spoken with the staff in Senator Laird's office about this bill because I was just curious about what they thought the prospects for passage for, to let them know informally that what the benefits would be for our agency, trying to stop short of advocating for passage, which is prohibited. But they asked me if I'd be willing to write them a letter. And I told them that I was leery of that because we do have Government Code Section 8288, which includes an employee or member of the commission appointed by the governor shall not advocate the passage or defeat of any legislation or the approval or veto of any legislation by the governor in that person's official capacity as an employee or member. And so I guess I'd like a reaction from the commission on whether I could send a letter to Senator Laird's office that's purely informational, that just explains, here's how we used to meet, here's how we met in teleconferencing, here are the advantages and disadvantages of teleconferencing that we've seen, but without saying you should change your bill, or you should this should be passed, especially if this letter gets passed around as, you know, part of the senator's advocacy for the passage of the bill, if he shares it with committees or other members. So, you know, I feel like it's dicey, and that's why I didn't proceed earlier. But I do think it might be possible to skate safely up to the line. And so I'm curious whether the commissioners.
Like
would like
Jane
me-
has a thought, and so do I.
Yeah, I think it would be a great idea, because I don't know that they, you know, the legislators can be completely familiar with how we proceed in this particular commission. And so I think if you lay it out in a purely nonpartisan way about the logistics and what it enables, I mean, I didn't want to pile on about the accessibility, but that's been my concern all along about going back in person, because we rely so heavily, not just on audience participation, but also on having people who have expertise in the topics that we're studying. And I think you're more likely to get a yes if someone can just, you know, pivot from something they're doing in their office,
Yep.
you know, appear before us, then pivot back, because we need those people who have that intelligence and that expertise to help us in our studies. So anyway, I am a big fan in favor of the letter, and you are very adept at how you approach these things. So I have no doubt that you will be able to finesse it and make it non-objectionable. Anyway, those are my thoughts.
I love that. And Brian, I have a suggestion for how we can do this.
Sure.
What if you draft it, but you're not the author? Some or all of the commissioners are, because you, Brian, don't have an unofficial capacity, but all the rest of us have other capacities that we could write in. And we can be a little bit more aggressive in those not official capacities and saying, you know, whether we think this is a good idea or a bad idea.
Yeah, I feel a little uneasy about that.
It's
because-
riskier, but it's clearer
requires-
than you doing it.
Yeah. I think that if I do it, or the chair signs the letter, or whoever, that I can stay on the right side of the line.
Mm.
I think if the letters come from commissioners with, on the other side of that line, and the justification for doing that, notwithstanding that statute, is I'm taking off one hat and putting on another hat. To me, that feels a little thinner in terms of justifiability. I mean, I certainly, if that's what you want to do, you can do it, but it makes me uneasy.
Okay. Let's see what our colleagues think. I see the ambassador and Xochitl.
And Rick Simpson.
Okay.
Yeah, Commissioner Carrion, you were up, your hand was up before mine. Go ahead.
So my thoughts on that is, I think that as individuals and members of the publics, we can go ahead and write those kinds of letters and obviously identify our titles for identification purposes only, and not as, you know, members of this body. I do think that it would be skating thing. I feel more comfortable if it would come from Executive Director Eber, and we're able to support that. I think if someone feels strongly, like I would feel strongly about it, given, you know, my childcare responsibilities and other individuals based on their personal experience, to inform the people who are making this decision what the real life impact has. I think that would be moving and powerful, but I think we should make sure to make those lines very clear.
Ambassador.
Yeah, I agree with the commissioner. I would be more comfortable with the executive director sending the letter. It provides more control over the content, and the commission as a body speaking en masse would look to me far more like what the statute is supposed to prevent us from doing. So I'm more comfortable, Brian, with you drafting it. Also, quite frankly, I think you speaking would carry more weight than the commission as a whole. given your familiarity with the process and the degree to which you're known in Sacramento.
Viceroy?
It makes me a little bit nervous. I would be interested if Kara has any thoughts. 6 or 8 years ago, I would have asked her, directly, but if you want to do a letter, I think it's appropriate for Brian to respond to a request from Senator Laird about the legislation. He's contacted them. If Senator Laird's office asked him to write back and let us know, how it would impact the commission, that seems to me to be fine. Something coming independently from the commission to the senator's office honestly makes me a little uncomfortable.
Sounds like they did ask. Kara, thoughts?
Yeah, I agree. I agree with that. I'm sure if Brian were to reach out to the senator's office, they might be able to craft something that we could respond to. But I also was wondering if maybe we have partners who, during COVID, for instance, the Fish and Game folks who attended, maybe they might be willing to also submit some things, just supporting the fact that attending our hearings was very beneficial, and that, I don't know, it's just another angle to consider. But I agree with Rick. But I think if obviously we'd probably want to review it before we send the letter.
The full commission?
That would be my preference.
Well, May's just around the corner, so it shouldn't be a problem to do that if that's your decision.
See Victor's hand.
Yeah, this is a thought independent of the letter, but I thought maybe thematically it's something we should discuss or put out there. Just the concept, borrowing from nonprofit organizations, the concept of an actual annual meeting in person, because by us pressing so hard for non-presence, it kind of suggests, a lack of cohesion, I guess, or an unwillingness to meet. And by that, I'm not looking for a junket. I'm saying we could just volunteer to pay our own way. The Southwest Airlines ticket is not very much money. So I'm not asking for an annual junket for us to go, but it would be good if we actually say at least once a year, we would try to have an annual in-person meeting of all the commissioners, because that's what a lot of nonprofit organizations do in these hybrid times.
Interesting. Well, I think that the decision on how to structure the hybrid meeting / in-person meeting probably needs to wait until January, because the law will not have changed yet in a way that enables us to do that. So we'll see. Now, importantly, the Open Meeting Act requirements with respect to teleconferencing only kick in for members of the commission. So if members of the commission participate remotely, that's when the complications arise. We can still get witnesses, non-commission member witnesses, to participate, but it would have to be in a hybrid format with all the sort of operational difficulties that come with that. In any event, I see one more hand.
I was just going to mention, I think that for some people, maybe a Southwest ticket might be a lot. We have a lot of lawyers who work at nonprofits and do pro bono work and other kind of participants. So I think that's something to keep in mind also when we're looking at the diversity of the board. We are also very active in ensuring that we have a lot of representation from different communities here in all kinds of spokes of identity and all kinds of life experiences. So to me, I think it's also very important to keep that in mind.
Yeah, I think the commission can afford to pay for commissioner travel. We used to do it for all our meetings, so we're actually realizing a lot of savings. As I said, Tom Green's going to start at 10:30, so maybe if there's no more discussion on this topic, maybe we could turn to the ERA so that the student can make her presentation. And then
Next item.
come back to the agenda. So we'd be taking it out of order. I'm going to promote Grace, who right now is just a still photograph
So I'll provide a brief introduction while that happens. So this term I've been working with Grace Wiley, who's a student at UC Davis School of Law. She was the primary author on the memo that's before you today. And I just want to give a little bit of context of how that fits into the study overall. At an earlier meeting, the commission considered the scope of the term sex for the purposes of this study. And that memo focused mostly on federal employment discrimination law, with a brief note at the end that California law actually expressly covered a lot of the grounds that federal law, the courts had interpreted the term sex to include, but California actually expressly put those into the statutes. And what Grace was asked to look at was the California laws, the California anti-discrimination provisions that had this language, and where the language came from, some of the legislative history around why that happened. And she presented that in, gosh, I don't have the memo number before me, but the memo that's before the commission today. And she's here to present the memo and give the information to the commission. And I'd like to welcome her and thank her for all of her hard work this term.
Thank you, Kristen, for the introduction. Like everyone said, my name is Grace. I'm a second-year law student at UC Davis who has been externing for the commission this semester. Before I start with my presentation, I just wanted to thank you all for allowing me to be here and allowing me to present on my memo. It's been a real pleasure to work for the commission this semester and to work closely with Kristen on working on this memo. And I'm excited to tell you a little bit about what I found and what I wrote about in my memorandum. I wanted to start with a more general note that this memorandum is meant to just be a piece of the bigger picture that the commission will need to consider later on for its overall Equal Rights Amendment project. This memorandum describes recent history and the current state of California's anti-discrimination laws with respect to sex. I won't go into all the laws in the memorandum in detail now, but I hope to highlight a few of the things that I found interesting and that are important, just to note the sense of the general policy direction that California has taken on the issue of sex discrimination. Within this, I also hope to highlight how the different provisions of the California Code vary in their use of the terminology for sex and gender discrimination. This memo discusses California's Fair Employment and Housing Act, provisions of the Education Code related to educational equity, and the Unrest Civil Rights Act related to discrimination by business establishments, as well as a brief note about the Penal Code's hate crimes definition. The memo also describes recent legislation affecting those laws and their treatment of sex discrimination. So as we all know, and as the commission has previously discussed, language plays a very important role in conferring protections, specifically in terms of the role of terminology and the scope of sex as it's defined. Thus, California has passed various legislation to clarify ambiguities about the scope of the protections it gives to sex and to expressly protect certain categories within its laws. California has done this as part of its broader effort to expressly protect sex and gender within its anti-discrimination laws. One example of this legislation that I described is Assembly Bill 887, which is known as the Gender Non-Discrimination Act. This bill was authorized at the time by Assemblymember Atkins in 2011 and made widespread changes across various codes regarding its anti-discrimination protections, clarifying that these protections for sex include gender, and that gender includes a person's gender identity and gender expression. The goal of AB 887 was to reduce any ambiguities in California's anti-discrimination laws about the scope of the protections given by expressly protecting gender identity and gender expression. Another example of this was within the California Fair Employment and Housing Act, which I'll refer to as FEHA as in the memo, under which subsequent amendments have been made to define sex and to expressly cover discrimination based on sexual orientation. An example of this is AB 196, which passed in 2003, which clarified that the scope of sex discrimination and harassment prohibited includes discrimination based on the person's gender, which was considered to be important by bill author Assemblymember Mark Lino, given the effect that gender-based discrimination has on one's ability to obtain housing and employment opportunities. Another example of changes in legislation is in the Education Code, which includes provision governing sex segregated activities and single gender schools. For example, the discrimination protection in Education Code Section 220 was amended in 2007 by Senate Bill 777 to remove the term sex and replace it with the term gender in its list of prohibited bases of discrimination. Within this gender term was defined to mean sex and to include a person's gender identity and gender-related appearance. These changes were made to create consistency within the language of Section 422.55 of the Penal Code, which is California's hate crime statute. Thus, in summary, despite differences across California's many anti-discrimination provisions, California law generally broadly extends protections for sex and gender. By doing this, California has shown its commitment to fighting sex discrimination by expressly and explicitly clarifying the scope of its protections across the California Code in order to ensure the broadest level of protections are extended. Like I said, this isn't, completely extensive and doesn't cover everything that was included in the memorandum, but hopefully it's offered a, broad glimpse of what the memorandum covered and what the goal of my project was in this. So yeah, thank you for listening. I'm happy to answer any questions that relate to the memorandum. Yes.
So the context of at least part of this memo is the commission's discussion about what kind of terminology we should be using, whether that matters, whether terminology is a red herring or if it's a key concept that we should be sorting out here. And I'm just wondering, in your, from your global perspective, having reviewed all these various statutes, they do obviously have some variation in terminology. So two questions arise. One is, did you think that there was any substantive distinctions that the legislature intended when it did use different terms? And if so, what is that significance? And then that leads to the third question of, what if any, takeaways does the commission have from your research for what kind of terminology we should be using? So what's your perspective?
Yeah. My first comment would be that language definitely does matter. And I think through these amendments, the legislature has, noted that. A lot of the ambiguities that existed before a lot of this legislation was within the fact that, generally California was said to offer protections for sex and gender, but didn't explicitly note the gender component of it. Therefore, a lot of this legislation was geared at including gender as a main component and as a defining characteristic of, or as included in the definition of sex.
Yeah, it's fairly easy to read the statutes. It seems like the legislature in many instances uses those terms interchangeably, perhaps unconsciously so. And at other times, as you mentioned, like technically speaking, gender is from a certain perspective a subset of sex as the larger category. But that somewhat subtle distinction doesn't exactly jump out of the statutory definitions. So I'm not sure that the legislature seems to be doing that consciously.
Yeah, and like you mentioned, it is kind of confusing and it is unclear, and there are differences across, the anti-discrimination provisions and within the code provisions. I think generally, they noted this in the Unrest Civil Rights Act, and amendments to it, that a lot of this legislation came from California wanting, for example, business owners to know that gender discrimination is included within the broader category of sex discrimination.
Right.
And so I think, it is confusing, and writing this memo took a lot of time to figure out kind of the circular way that this works, how sometimes gender is defined, or gender is included as a definition of sex, but then later on sex is included within a definition of gender.
Right.
And so, I think California legislature is still working through it, but this legislation shows broader attempts to clarify any ambiguities existing in regards to, making these protections as broad as possible.
So it sounds like there's no, sort of statutory command takeaway that the commission has to abide by in terms of, adopting a particular definition or a functional distinction between sex and gender. It sounds like you're agreeing that the legislature does use those somewhat interchangeably sometimes.
Yeah, I think there is a broader push to ensure that gender is included within those definitions.
Right.
As society has gotten a lot more expansive in how we, are accepting of others and how people identify. And so, I think in a lot of these code provisions, sex was typically the only term used.
Right.
And in reality, that doesn't cover everything that needs to be covered according to the California legislature. And so I think while there's not really like a statutory, requirement that the commission follow, in general, there has been a bigger push to ensure that gender is explicitly protected within these code provisions.
So, where I'm going with this is I'm wondering if you'd be comfortable based on what you reviewed. How comfortable are you with the kind of tentative draft, working definition that the commission at the moment is going with of using sex as a very broad umbrella term and then unpacking it in some detail to include things like gender and gender expression and gender identity in a longer definition. So it would be we're using kind of a typical statutory construction of sex hereby defined as, and then you have a very long paragraph, unpacking that. Does that work for you?
I think that makes sense. I think that's what a lot of, there are differences like in the education code where it's a lot more circular and, gender being a lot more fluidly used. But I think in overall, California does abide by that path of noting sex and then very explicitly later on defining that as including gender, as including gender identity, as including gender expression. And so, a lot of those differences in the education code are, related to, single gender schools or sex segregated activities. And so in those cases,
it is interchangeable.
Yeah, the legislature might have found it more important to,
right,
have a definition that includes both of them. But, I think for the commission's purposes, having a broader definition or broader statement of sex and then defining it later on does fit more broadly within what California has shown through its legislation so far.
Okay, that's helpful for me to clarify the issue in my own mind, because I see this as having to strike a balance between being thoughtful and inclusive on the one hand, but also not chasing our tails on the other hand and getting caught up in, a technical issue when we should be looking at the more substantive issue.
Yeah, and Kristen and I spent a lot of time kind of, debating the language of it, and whether, I think we talked about one time whether if we note sex and gender, whether that explicitly like notes that we're not including other things, and I think sex has more broadly been used. It's okay to start with that and then later on make note that that includes, all this list of other categories
Okay.
too.
Thank you. That's very helpful. That makes me feel more comfortable about the path that we're taking for the moment, and it helps me distinguish this from something like the debate over terms for the ethnic group that's sometimes called Hispanic and sometimes called Latino. Those actually are very distinct terms, and they describe very distinct groups, and they're not necessarily synonymous at all. I think this is different from that.
Yeah, I do too.
Okay, great. I've been monopolizing. I think Kristen has a hand up, and then I was going to go to the other commissioners.
Yeah, just the one thing that I wanted to note is it does seem like a more modern movement in the California legislature has been to use the term gender as the sort of main term. And that's definitely what we saw in the education code was the more recent amendments typically, put in gender as kind of the catch-all. So I do just want to note that. I think that the other thing that's really important about what California has done is California, expressly puts everything into the statute. We don't leave it up for interpretation what we're talking about. We want to be clear about what we're covering and be proactive about that. The previous memo about federal law they waited to have all these Supreme Court cases, and my whole memo was about Supreme Court cases interpreting the term sex. California, the legislative developments have not been like that. They've been more forward-looking, the legislature moving ahead and providing express protections through the statutes, either through the definitions or on the list, and in some cases both. Even where gender is expressly defined to include gender identity and gender expression, those would be listed as separate protected classes in some of the statutes. So California really tried to cover its bases in terms of being really express about how broadly we're trying to extend these protections.
Yeah, and I guess one benefit of, if we're going with a working definition of sex and gender as being mostly interchangeable, we can just switch gears and use gender as the umbrella term, and then, it's like we're not married to either one of them. And so if you folks on the staff feel like there is a trend, to use one or the other as the umbrella term, whatever. If they really are interchangeable, then let's use whatever the current one is.
Yeah, I mean, we'll keep our eye. I mean, I do think, to me, this look was sort of suggesting that California was sort of moving towards gender more as the broader term, but they are still somewhat interchangeable, I think.
That works for me too. I've been monopolizing. Let's see what my colleagues think. Ambassador.
A question and a comment. If we were to move toward picking a word, I might not instinctively favor gender. In the United States, there's been the cultural overlay of only two genders, which is quite distinct from many indigenous cultures where there are three genders. So within our culture, using the word gender sort of puts an oar in the water. Now, I'm not suggesting we determine that now. It's just gender is a cultural artifact rather than a biological or expression artifact. Grace, I've got a question for you since we're dealing with terminology. And thank you, first of all, for the excellent report. You've clearly done a ton of work. You answered the chair's questions very fluidly. Your school is providing good return on your tuition. My question about words is, they're not just nouns, they're pronouns. Are you seeing a trend in what you've seen about the appropriate use of pronouns when we're dealing with a complex issue like sex?
First off, thank you for the very nice compliments. It's very sweet.
People often tell me I'm the opposite of sweet, so I'm going to write down that.
Then you should take it
and cite it to other people later.
To answer your question, we didn't exactly cover, a ton about the use of pronouns, but I do think, specifically in regards to a lot of the pregnancy provisions of these anti-discrimination provisions, pronouns have been almost entirely eliminated. There's been a push for a lot more gender neutral language, which I think, gets to the idea that there's lots of pronouns out there, and it's mostly only mentioning he or she doesn't really include the, or in the pregnancy related, just using she doesn't encapsulate, the wide variety of pronouns used. And I think, there's been a bigger push overall, not just in the pregnancy provisions, but in general to provide the broadest scope of protections possible. And I think removing any gender specific language specifically within the pregnancy provision is just one example of that. And, replacing it with neutral language. But like I said, we didn't really cover the full extent of, the idea of pronouns, but in general, I think, it fits in line with California's overall goal to extend protections more broadly.
Thank you.
Commissioner Carrion.
Yes, I'll also echo the ambassador's comments. Excellent work, Ms. Wiley. Thank you for your contributions. It's been wonderful to hear you present and have another person that's becoming a subject matter expert in these really important fields. So I think my comment has to deal with more to me, the study of gender and sexual orientation and gender expression and sex and all those things has really evolved and changed recently. It is very recent in our California legal landscape in comparison to other laws. And I think that when you were talking about the different variations of that interpretation and the language being used, it really shows to me that this is something that we are as a society looking at more heartfelt manner and more thorough manner. Given that this is such a new field from my perspective, especially now that it is being studied and worked on not by those that are not of those communities, but specifically by people who have that lived experience and have, you know, trained in that. So it isn't an outsider coming in and, you know, kind of having this academic approach. So my thoughts are, what are some of the challenges that you see in creating language that really expresses this moment of kind of societal evolution of understanding of gender, sex, gender expression? I can imagine, I wouldn't be surprised within 1 year if we start using a completely different term or a different way of expressing these things. And, you know, that's going to keep happening. I mean, I think that this is a very important and novel legal issue, while persons of these, you know, non-binary, trans, all of those, you know, communities have always existed, right? But to have them now protected through the laws and articulated, it is relatively new. So what do you see as some of the challenges of creating language that is forward thinking and gives space for the evolution and the changes that society continues to have as we learn more about our fellow, you know, like community members?
Hi, yeah, thank you again for the very nice comments. You know, to your comment and question, yeah, I think California has, you know, taken the challenge and, you know, gone with the movement of society in trying to, you know, explicitly note these protections within its provisions. And I think a lot of California's amendments show its attempts to do this, though it's not always clear. And it sometimes is confusing, especially when, you know, even though some of this broader legislation applied to a variety of anti-discrimination provisions, you know, obviously ambiguities and differences remain. And I think the education code is so unique in this and showing this challenge of, you know, like we talked about earlier, the importance of language and what to explicitly include in order to extend the broadest protections possible. Because California has noted that that's its goal, you know, but to do that in practice and through language is another thing. And I think the education code, you know, there's been amendments that have taken out the term sex, included the term gender, and then within the term gender, defined it as including sex among, you know, gender identity, gender expression. And so I think that in itself shows kind of California's battle with, you know, looking to protect these gender and sex more broadly, but still not sure how to note that and be consistent across its different provisions, especially in the context of, you know, the education code with, you know, when there are still, you know, Title IX considerations and, you know, sex segregated schools and, you know, these smaller nuances that don't exist in other provisions or in other, you know, broader areas. So I think in general, California's challenge will be just to, you know, kind of do the battle that we were doing a little bit earlier in figuring out what terms need to be included to extend these protections as broadly as California wants to, without them not including language as being interpreted as California not extending those protections to those categories. And so I think finding a balance that achieves both of those is going to be California's biggest challenge.
Mr. Executive Director.
Thank you, Grace, for the presentation. Excellent job. I often think about how to future-proof statutory language so that it covers what it needs, is known needs right now, but is also open-ended so that it can cover unanticipated future needs. And my thinking, and I'm just putting this on the table, not asking for a decision or anything, but My inclination on this kind of thing would be to structure the definition as a general principle and then include a non-exclusive exemplary list. So you could say something like discrimination, sex discrimination is discrimination on the basis of sex, including any characteristic that is related to sex, including but not limited to the following, and then you run through the laundry list. So somehow to basically say what we're worried about is discrimination that is derivative of one's sex, and that includes not just their biology, but pregnancy, reproductive health care, gender expression, gender identity, etc. And if you leave it that way with this non-exclusive list of examples, then you make clear these are the things that we are definitely covering. And so they serve as illustrations, right? So you don't rely on anybody to infer anything, but you don't close the door to further expansion if there are other characteristics that are tied to sex discrimination that aren't in the list. People would have a better handle on how to argue for expansion of the concept if they had a list of things that the legislature said these are in. But that's just my inclination as a drafter. But
Brian, I was thinking in much the same conceptual direction, like like I would go even further. Don't discriminate against people based on their intrinsic characteristics. Accept people for who they are. Including but not limited to.
intrinsic characteristics would go beyond the scope of our authority in this study.
I know, but I'm agreeing with you that there's a core concept here of, don't be a jerk. Just like take people for who they are and
Don't be a jerk,
discriminate against
including but
them
not limited
because
to.
of who they are. Yeah. If I could legislate, don't be jerks, our jobs would be done. Should we move along?
Well, Mr. Green has joined us, but he's
Yeah.
not expecting to start for another 6 minutes. So if there's anything more that anyone wants to say about this topic, we have a few minutes.
Going once, going twice. Victor? No? You look
I
like you're
suggest
thinking-
a 5-minute break.
I was thinking in the same direction.
There you go.
Seeing no further comments from my colleagues, Grace, terrific job on the memo, well written, very good presentation, and you fielded some tough questions from the commission. Really proud of you. Good job. Thank you, Kristen. You should be proud of her as well. And let's take 5 and resume at 10:29-ish.
Ish. Okay.
Thank
Will
you
do.
all.
Thank you, Grace.
Hi, Brian. Just checking sound. Am I good?
Yeah, I hear you.
Cool. Okay, great.
See you soon.
And you're going to run the most recent